evidence in this matter has been heard. The problem with evidence is that it is not all delivered at one time simultaneously. That's the nature of evidence. It is delivered seriatim, and one hears one side before one has heard the other side, and one must wait till all the evidence is in before one makes a decision. Now, I don't prescribe to the press how they should deal with the matter. The press will do its business, I will do my business. But it would be appreciated if it could be said at some time that no evidence will be decided upon, no evidence is accepted, no matter who the witness is, until such time as all the evidence is heard. This matter is urgent and should be dealt with urgently. It is not every day that you'll find a developing country like ours featuring on the front page of the New York Times for the state that is alleged to be its tax collector. Not only on the front page of the New York Times on one day, but a week later, a full spread on page 4 of the New York Times. The state of any country's tax collection system is of great relevance and interest to people who invest here. That is why this commission I regard, and I would imagine the President regards, as urgent, and that is why the time that has been allowed is fairly short. I believe that it is time for things in SARS which have been written about in the press, whether accurately or inaccurately, I don't yet know, to be brought into the sunlight. The sunlight is a great sanitizer, and that is what we intend to attempt to do in this commission to the best of our ability. Now, I received last night a letter from Mr. Makwakwa. He asked to be heard in this matter, and I have assured him this morning that he will have the opportunity to be heard. He also stated in the letter that he disputes the evidence that has been heard in this matter. He says that he wants to tell his side, which is a very different side, and I accept that he may well be correct that there is a very different side. I did phone him this morning and tell him that this commission will be terminating its session today and probably not be resuming for some weeks. And did he want me to disclose this letter now so that people know his attitude before we wait for 4 weeks to resume? And he asked me to do so. I'm not going to read the letter out, but the letter will be available from Advocate Steinberg. I'm not sitting today with Professor Katz and Mr. Koshler. They are not available today. They obviously have lots of other commitments and have not got days and days on end available, but that is the reason that they are not here today. Thank you. Mr. Mpofu, you wanted to make some submissions.
Thank you very much, Judge Nugent. Yes, thank you. If I may start by just introducing the members of my team. I am assisted by my learned junior, Ms. Sibuku, from the Johannesburg Bar, instructed by Mr. Eric Mabuza, the attorney, and we are in the company of the client, Commissioner of SARS, Mr. Tom Moyane. Thank you very much. We would like to, with your permission, Judge, hand up a copy of submissions which we have prepared hurriedly overnight. And maybe also hand up a copy to our colleagues, the evidence leaders. I will not read the whole statement. I'll just read certain parts of it and then speak to it, so to speak. It is headed Summary of Objections by Mr. Tom Moyane, the Commissioner of SARS. And the introduction says that the submission seeks, in summary, to articulate the strongest possible objection against the institution, the conduct, and the continuation of this commission. And that this commission, rather, the submission covers three broad topics, namely 1, gross unfairness, 2, inherent bias, and thirdly, the relief or ruling that is sought from yourself with respect. We go on page 1 to, we just give a factual exposition and a brief history, starting with the 18th of March, when the President called Mr. Moyane to attend a meeting at his house in Hyde Park, at which meeting the President shouted angrily at the Commissioner while telling him that he, the President, had in fact lost confidence in the Commissioner because of essentially 2 issues which had apparently been reported to him by unknown persons involving alleged governance breaches at SARS. More specifically, the President based his angry outburst on 1, the alleged payment of VAT refunds to an alleged Gupta-linked taxpayer, and 2, the handling of the disciplinary process of Mr. Jonas Makwakwa that you mentioned earlier, Judge, who was a senior executive at SARS. We outlined that on the 19th of March 2018, the President took a decision to suspend Commissioner Moyane from his duties pending a disciplinary inquiry. On the 2nd of May 2018, the President issued the charge sheet in the inquiry, and we've attached a copy of the charge sheet. The following day, on the 3rd of May, the President issued terms of reference in respect of that disciplinary inquiry and appointed former Constitutional Court Judge Justice Kate O'Regan to chair the inquiry. We've also attached a copy of the terms of reference as B. On the 16th of May, Commissioner Moyane successfully objected to the appointment of Justice O'Regan on the basis of her conflict of interest, as she sits on the board of an organization which has and continues to issue disparaging and defamatory remarks about Commissioner Moyane in respect of his employment at SARS. On the 21st of May 2018, the President announced the appointment of Advocate Azarbam SC to replace Justice O'Regan as the chair of that inquiry. The disciplinary inquiry, just for background, is currently at a stage where an affidavit has been submitted on behalf of the President, and Commissioner Moyane has been given until the 2nd of July, which is next Monday, to respond. And we say that in his response, the Commissioner will, among other things, reiterate his long-held view that the inquiry ought to be conducted in a fair manner, which should be obvious, including prescribing the hearing of oral evidence and the right of cross-examination. It is not clear why the affidavit on which the President's loss of confidence is based is deposed to by Mr. Pravin Gordhan, who is the Minister of Public Enterprises and has nothing to do with SARS employment issues, or should have nothing to do. We say, curiously, there is no evidence which emanates from the Presidency, the Minister of Finance, that is the Treasury, or any relevant Treasury officials that has been submitted in support of that disciplinary inquiry. So the lone voice is Mr. Gordhan. On the 24th of May, the President appointed this Commission of Inquiry. The panel of the commissioners consists of yourself, Judge, Professor Michael Katz, who is the chairman of ENS Africa Attorneys, a firm of practicing attorneys based in Sandton, Mr. Kahla, and Ms. Advocate We then attach just for completion, the terms of reference. Obviously, you are familiar with those. On the 20th of June, 2018, you, Judge, addressed a letter to Mabuza attorneys who act for Commissioner Moyane in the disciplinary inquiry, and we've annexed a copy of that letter. The relevant portions of that letter say that you wrote to Mr. Mabuza, quote, to inform you for your information and as a courtesy to your client that the Commission of Inquiry will be hearing evidence in public from 26 to 29 June 2018 in Pretoria. In response, Mr. Mabuza sent a letter, a copy of which we annex as E, requesting an opportunity to raise certain concerns and objections. Inter alia 1, the unfairness of having Professor Michael Katz, who is the personal and business attorney of the President, as a commissioner in a commission which essentially investigates Commissioner Moyane's alleged governance breaches at SARS, the same subject matter before the disciplinary inquiry. I'll talk about that a bit later. And 2, the need to receive an assurance that this commission will not straddle into issues which are in dispute before the disciplinary inquiry. I'll also elaborate on that a bit later. Yesterday, the judge eventually confirmed that Commissioner Moyane would be given audience today at 9:30 as per his request of 22nd June 2018. In the short space of time available, Commissioner Moyane consulted with his legal representatives in order to produce this submission, which had to be done overnight due to the short notice. Now, coming back to the activities of this, having painted that background, coming back to this particular commission, we state at paragraph 16 that on the 26th of June 2018, this commission called as its first and apparently main witness Mr. Gordhan, who had prepared a 140-page presentation extolling the virtues of his tenure at SARS as commissioner and giving some evidence of his encounter with Commissioner Moyane at SARS headquarters virtually within 24 hours of his reappointment as Minister of Finance on the 14th of November 2015, when he came armed with a 10-point plan that he mentioned here of operational changes which needed to be done or undone at SARS. And we put in brackets that although he did not mention it, this was the time on occasion on which he refused to shake Commissioner Moyane's hand and publicly and arrogantly humiliated him in front of his subordinates. Mr. Moyane, when he describes that incident, it's actually shocking. Don't shake my hand, said Mr. Gordhan. Who do you think you are? Didn't you know that the wheel turns? Didn't you think I will be back? And so on and so on. And curiously, as we say, within 24 hours of his appointment, he already had a 10-point plan for SARS. We say the thrust of Gordhan's testimony here was that his tenure at SARS, I'm sorry, Judge, I should have apologized. I have a bit of a flu, so.
Don't worry, Mr.
Yes.
Happens to us all at times.
Thank you. The thrust of his testimony was that, 1, his tenure at SARS was efficient and flawless. 2, that he instituted an operational model which was magnificent. And 3, that Commissioner Moyane unnecessarily changed the magnificent operational model. And 4, that there was evidence of, quote, state capture, unquote, in respect of SARS management under Commissioner Moyane. The important part is paragraph 18, that what Mr. Gordhan's testimony was important for is for what it did not say, which is that, 1, firstly, he did not explain how he came to be the first witness to be called and how he happens to be in possession of documents which belong to SARS or Treasury. 2, he did not explain that he himself had collection revisions or so-called shortfalls of up to 60 billion much higher than the much vaunted 50 billion several years later. And if I may pause here, a lot has been made out about this so-called 50 billion and the amount of money that could have been used for the poor and all those kinds of stories, without understanding how a tax revision or shortfall is arrived at. 3, we say he didn't say that the collection revised targets are based on the performance of the economy as jointly assessed by SARS, the South African Reserve Bank, and Treasury, and how naive it is to operate from the premise that such shortfalls can be determined by inquiring into only one of those decision makers, such as SARS. And here what we say is that the revision is not so much about the ability to collect than it is about the economy to produce a particular outcome. Obviously, if the economy performs less optimistically than envisaged, then targets have to be revised. But there seems to be this narrative that it's all about collection. In other words, you can just extract from the economy billions that are not there, or where there's, the tax morality has gone substantially low. Anyway, Mr. Godan also didn't tell you that the first time in the history of South Africa that more than 1 trillion rand was collected was under Commissioner Moyane for the fiscal year 2015-2016. This feat and milestone was repeated under Commissioner Moyane in 2016-2017, and more recently in 2017-2018. Godan has never collected 1 trillion rand for the South African economy under the magnificent operating model of his. 5, he didn't say that under Commissioner Moyane, the tax extraction rate, also known as tax to GDP ratio of South Africa, reached its current levels of 26%, which is unprecedented and one of the highest in the world outside the Nordic countries. And it is much higher than the USA. Again, this is a feat which was not achieved under the magnificent operating model. He also didn't tell you that the degrading and condescending manner in which he rudely addressed and treated Commissioner Moyane, which I've referred to earlier, with open hostility and aggression, if not downright hatred for Commissioner Moyane, which is well known and by now legendary. He also didn't say that Godan, was the author of the 67-page affidavit intended to prove that Commissioner Moyane was guilty of multiple counts of breach of governance during the period under investigation in this commission that is now under the Azabam Commission, or rather inquiry. Finally, he didn't tell you that the operating model was only changed following a presentation of the need to do so presented in Parliament by Ivan Pillay as part of Pillay's 2014-15 annual report, when Pillay was acting commissioner, and subsequently implemented with the approval of the SARS Advisory Committee led by retired Judge Kroon and Minister Tlanhlanene. We state there at paragraph 18.8 that proudly the operating model produced subsequently under Mr. Moyane's watch, inter alia produced the following: revenue targets being met or surpassed, empowerment of Africans and African women in particular after years of marginalization, and an exco with all members who have tertiary education, of which 38% are African. And the question about the tertiary education is more significant if it's viewed in the context that a person who was acting commissioner, Mr. Ivan Pillay, apparently does not even have a matric certificate. Those days are now gone. that black men or African men and women representation in management has deteriorated. We've got the figures that can show the current status. And then we say, following Mr. Gordhan at this commission was a string of disgruntled former employees of SARS and members of the notorious rogue unit, which was independently found to have unlawfully existed under the magnificent operating model of Mr. Gordhan. It would be fair to say that all witnesses called have had one theme in common, that Commissioner Moyane was guilty of multiple instances of breach of governance and other abuses. An effective reign of terror by him and others associated with him or protected by him. Everyone else was allegedly purged despite their innocence and dedication to SARS. Judge, you made references to the New York Times and other publications, and we say, unsurprisingly, the South African media, and one might add other media, has correctly reported this commission as being about the misconduct and abuses of Commissioner Moyane. I won't make the examples. I can even rely on some of the ones that the judge referred to. But they all reflect the sentiment prevalent in virtually all South African print and electronic media. Curiously, somebody yesterday, one of the callers in a radio station referred to this as the Moyane Commission. And one can be forgiven for calling it that, because everybody who has sat on this chair has been going on about the terrible Mr. Moyane. All this is occurring in a situation where Commissioner Moyane has not been invited to this commission, and neither has he been contacted by the evidence leaders, as appears to be the case with other witnesses, particularly those who came armed with 140-page presentations. Yes. And then we say we'll now then deal with the specific issues, having painted that background. Our view can be prefaced by stating that if this exercise goes on as it does now, it will be nothing more than a monumental waste of taxpayers' money, ironically, when it is about tax collection. Then we deal with gross unfairness. Fairness is one of the cornerstones of our constitutional democracy. The state in particular bears a particular duty to act fairly, both substantively and procedurally. The judge knows more than I do that the notion of fairness really defies any precise definition, but you know it when you see it. And that it is something that should be tailored into specific circumstances of each situation. Now we say here, the inherent and glaring unfairness of the process followed in this inquiry can be approached from a multiplicity of angles, which all come to the same conclusion, that this is one of the grossest and most unfair processes ever witnessed under this democracy. Without exhausting all the instances of unfairness, due to the limited time, we deal with the following topics. 1, the failure to invite the commissioner. 2, eliciting evidence adverse to the commissioner's rights without giving him an opportunity to rebut it. 3, the choice of witnesses. And 4, facing 2 inquiries by the same person, the president, with the same principal witness, Gordhan, into the same or an overlapping subject matter. As I've said, fairness, there's no one-size-fits-all definition of fairness. Starting with the first topic, failure to invite Commissioner Moyane. Although it is clear by now that Commissioner Moyane and his term of leadership from 2014 to date, in fact that is spelled out in the terms of reference, is the core issue of this commission. This commission did not see it fit to interact with him in any way, save to the unsatisfactory extent of the courtesy letter, for which we are grateful. By the mere fact of contacting Mabuza attorneys, this commission showed that it was fully aware of the ongoing disciplinary proceedings conducted under the auspices of the President and/or Mr. Godan. To pretend otherwise would be strange and unsustainable. The short notice given to Commissioner Moyane is, in any event, grossly unfair given the gravity of the issues and the allegations made against him daily in this room. And we say the failure to invite Commissioner Moyane is on its own unfair and unlawful, and an unlawful violation of his rights to defend himself. Again, one doesn't need to be a lawyer to understand the fact that if serious allegations are going to be made against you, you at the very least have to be there. You at the very least have to have a right to rebut those allegations, and at the very least you must be given to hear your side of the story. It's cold comfort, with respect, Judge, to do what you suggested in your opening remarks, that at some time in the future you may be called to make a statement. The point of the matter is that at the time when the adverse statements are being made against you, when predictably certain attitudes are being planted in the minds of the public, that is the time to exercise your rights to fairness, not in some future unspecified date. Then we go to eliciting evidence adverse to Moyane's rights without giving him an opportunity to rebut. That's what I've partly covered, so I won't read that section as it is. We've said that the same treatment has incidentally been meted out to advocates Kakane SC, whose commission report has been rubbished here 4 years after its release by persons who have never taken the report on review. That is patently unfair. Of all the lies told here in the past few days, the biggest is that the rogue unit does not or did not exist, and that Advocate Kakane's findings ought to be discredited, once again, without even giving him an opportunity to defend his report. The truth, of course, is that the rogue unit existed under Minister Godan, and to his knowledge, it was in fact reported to him in October 2007, I think, its institution. In this respect, Commissioner Moyane hereby hands over a memory stick containing a recording which puts the matter beyond any doubt. It will be left to the Commission to decide whether to release it to the public, which we propose should be done. This Commission must also obtain transcripts of the evidence given under oath before its Kakane inquiry by some of the implicated characters who have testified here. Incidentally, it has been established independently, by me at least, that these characters refused to testify before the ongoing KPMG inquiry chaired by Advocate Zabeza SC on the grounds that they are still facing criminal prosecution. They have, however, been keen to testify before this particular inquiry, and we suggest that the reasons must be that, having been recognized and consulted with, they were of the view that here they will not face robust questioning and will receive sweetheart and kid gloves treatment, because there can be no reasons why they would object to going to a proper inquiry under Nsebeza, but be so overly keen to rush here. Then we go to the question of choice of witnesses. Well, we say the witness list makes very interesting and curious reading. It suggests that there was an earlier evidence gathering stage to determine the alleged relevance of the evidence, and also some witness preparation. I'm sure our colleagues will correct us if we're wrong about that. It is, for example, unlikely that Mr. Godan simply woke up on 26 June and produced a 140-page presentation. And the aesthetics alone of Mr. Godan being the leading light in both the inquiry, disciplinary inquiry, and this one speak for itself. The witnesses are all persons who are disgruntled, some for very well-known reasons, which might become clear when the material we have donated to the Commission is listened to. We said the hostility, I'm sorry.
Say that again?
No, I was saying, I'm just developing paragraph 36.
Yes,
I was saying that might become clearer when the material in the memory stick is considered. The hostility of the principal witness and architect of this process, Mr. Godan, towards Commissioner Moyane is also well known, and that this commission would be hard-pressed to deny knowledge thereof. Everybody knows about this. Members of the rogue unit also have a huge axe to grind with Commissioner Moyane, and so would any other employee who, rightly or wrongly, regards himself or herself as a victim of the imaginary Moyane purge. Choice of witnesses exhibits that the Commission has prejudged the issue before it and is merely going through the motions to reach a predetermined outcome, which would be patently unlawful. And no amount of timid questioning can mask that fact. Next, we talk about a very important issue, facing two inquiries by the same person with the same principal witness into the same or overlapping subject matter. It is a trite principle of our law and the common law rules of fairness and justice that a person, one, cannot face two separate tribunals which are destined to return separate verdicts, findings, or rulings on the same subject matter. The underlying principle finds expression in the maxim of lis pendens, or lis alibi pendens. It's also tried that a person cannot be tried twice for the same offense, and the underlying principle is so-called double jeopardy. The overlaps between these two inquiries is self-evident, and I won't go through each terms of reference to isolate those. But one can think off the top of my head of issues, for example, to do with the VAT, not reporting matters to the minister, and so on. But there are quite a few overlaps. It is indeed so that, in addition, one of those two reasons originally cited by the President for his alleged loss of confidence, namely the VAT returns, miraculously did not appear in the charge sheet, only to resurface in this commission. The inference of an unlawfully orchestrated double-barreled attack on the commissioner is, in the circumstances, irresistible. One simply has to imagine the possibility of the two processes reporting two different outcomes to the same president to demonstrate the inherent absurdity in the present situation. The idea of facing two kangaroo courts at the same time on the same subject simply needs to be stated to be rejected. And before I quote that extract, I simply want to say, just to make this example, let's assume, for argument's sake, that this commission finds that Mr. Moyane is innocent, or it finds that Mr. Moyane is guilty, either way. And then the following day, he must go to an inquiry under a BAM SC to determine his guilt or innocence. Theoretically, it's possible that he might be found innocent here and guilty there, or guilty there and innocent here. The permutations are endless. But that would show even to a child the absurdity of, or rather the rationale for the rule that you should not face two inquiries at the same time about the same thing. The principle is also related to res judicata, which I won't elaborate, that's just legal stuff. Nafsa explained the basics in this of the principle as follows in the Supreme Court of Appeal. he said, quote, "It is necessary to consider the underlying principle of the defense of least alibi pendants. In that case of Nestle, this court stated the following, quote, "The defense of least alibi pendants shares features in common with the defense of res judicata because they have a common underlying principle, which is that there should be finality in litigation. Once a suit has been commenced before a tribunal that is competent to adjudicate upon it, the suit must generally be brought to its conclusion before the tribunal and should not be replicated, least alibi pendants. By the same token, the suit will not be permitted to revive once it has been brought to its proper conclusion, res judicata. The same suit between the same jury, same parties should be brought once and finally. This principle has been stated and repeated by the authorities over a period of more than a century. Double jeopardy is also a time-tested principle of fairness and justice, according to which, once found not guilty or liable in one set of proceedings, a person may not be subjected to a process to determine the same liability. Again, it would be easy to postulate that situation arising here if both processes are allowed to continue. I've already made the examples. We then say, if necessary, an exercise to demonstrate the commonality of the issues to be determined will be performed, in other words, in the two inquiries, will be performed with reference to the documents referred to above, and if necessary, the Godin affidavit in the disciplinary inquiry will be provided to the Commission. I have a copy here, but we just didn't make a copy. It's quite long. So if the Commission is interested in it, we will supply it. In this regard, additional factors to be considered include the inconvenience and financial burden being prejudicially placed upon Commissioner Moyane, and the looming possibility of a fruitless waste of taxpayers' money in meaningless proceedings, which are doomed from the start and will be mutually destructive, as I have explained. It is Mr. Moyane's considered view that the whole enterprise, viewed in totality, is just an unmitigated sham and a farce. Then we deal with bias. As far as bias, maybe before I move to bias, let me explain what we are saying there. And it is that there's a danger of each of the processes being undermined by the other, so to speak, and that might taint or contaminate irreparably both processes, unless a solution is found to the double jeopardy or least pendants situation that is currently prevailing. That's quite apart from just the sheer unfairness of expecting Mr. Moyane to be running around literally. In theory, these things could even be happening on the same day at some future date. So he might be expected to come here and listen to the unstopping allegations and his name being rubbished, and at the same time, BAM SC process could be continuing down the road. Again, one doesn't have to be a lawyer to realize the absurdity of that situation. Now, we deal with bias. Bias, of course, the judge will know, is itself a factor of fairness, but it's a standalone, we deal with it as a standalone heading. For example, the question of the selection of witnesses might exhibit bias, a certain bias, but it also is an issue under fairness itself. Then we go to the question of the conflict of interest, which is a subject of bias. We say a specific issue which deals with the reasonably perceived or apprehended bias on the part of Mr. Moyane is the choice of commissioners by the President. It is common cause that the President, and to some extent Mr. Godin, is the main adversary of Commissioner Moyane in the disciplinary inquiry. He and Godin as well are essential witnesses, or at least have put themselves in positions where they'll be essential witnesses. It is also not expected to be denied, and I'm sorry that he's not here, that Professor Michael Katz has habitually acted over the years to date in previous and pending proceedings for Mr. Ramaphosa. For example, the pending civil proceedings in which Mr. Ramaphosa is being sued by the victims of Marikana in his personal capacity. Sorry, it shouldn't say circumstances, it should be capacity, which had to be disclosed to Mr. Moyane. Other past and present instructions in respect of personal and or private business dealings may or may not have been in the public domain. The two gentlemen are known to be personal friends who have likely visited each other's homes. It would be interesting to find out if these relationships were even disclosed to this commission. If so, a copy thereof will be requested. As the old adage says, justice must not only be done, it must be seen to be done. The test is, of course, not actual bias, but a reasonable apprehension or suspicion thereof on the part of a potentially prejudiced party, such as Commissioner Moyane. The President could surely have appointed a person who is not well known to be his personal lawyer, so as to sustain a semblance of neutrality or impartiality. By going outside and even appointing a retired judge, albeit to perform an administrative and executive function, he wanted to communicate or convey to the outside world that the Commission is impartial and free of conflicts or the propensity to be better disposed towards a particular outcome desired by the President. Such conduct of appointing a conflicted person amounts to nothing but an abuse of power, which is also done in bad faith. The principle underlying this particular objection is nemo iudex in causa sua, which simply means no one should be a judge in his or her own case. In this case, obviously, that would extend to your, not just to yourself, but to your attorney or your agent of some sort.
So I should add here, it applies not only to the attorney, but to me as well.
No. Absolutely not.
I thought you said that.
No. I was saying, no, I was making an example. I was simply saying, Judge, the mere appointment of a judge like yourself is meant to communicate that this is supposed to be an independent and impartial body. Otherwise, they should have just done an internal...
And of course you say it's not.
No, absolutely. I'm saying it's not because of cuts, yes.
No, you're saying it's not. The appointment of a judge is to give the impression that it is independent.
Yes.
But you say, in fact, it is not independent.
No.
Or I am not independent.
No. That's not what I'm saying, Judge. I'm saying that the mere appointment of a judge, which happens in all the commissions, is meant to assure the public. Because remember, a commission is just an extension.
Just finish that sentence, to assure the public?
To assure the public that there is independence, right? Now I'm saying, if
you say that it doesn't assure the public because the judge is not independent.
No. Judge, I'll tell, when we have a problem with
We'll come back to that.
Yeah, when we have a problem with you, you can be assured that we will tell you without any fear or favor. What I'm saying is simply this, that the appointment of a compromised person, let's say for the purposes of this argument that Mr. Katz is compromised. If you appoint such a person together with a neutral judge, then you are just giving us mixed messages. Yes. Because your original intention was to convey neutrality. So it doesn't refer to the judge. And in any event, I must add this, by the way, that we do have other concerns even regarding the other commissioners, but not yourself. But we decided not to raise those at this stage and just raise the most obvious case and the most egregious violation of Mr. Moyane's rights. And so when we use the nemo iudex in causa sua principal judge, just to be, so that there's no debate about this. It refers specifically to Mr. Michael Katz as an extension of Mr. Cyril Ramaphosa. In other words, as his attorney. So he's judging his own case, obviously not literally, but as a person who acts for that person. Let me make this example. If, of course, and I must preface this by saying we know this is not a court of law or anything like that, but just to illustrate the point, what we're saying is that, let's say, for argument's sake, Professor Katz was appointed to act as a judge in the High Court. His professional and ethical duty, if one of his clients happened to be a litigant while he was acting as a judge, would be for him to recuse himself. And we're saying, similarly here, in a process which is intended to be impartial and independent, he should similarly recuse himself. Because the principle is the same. It obviously applies with much more force in a court setting. But the independence is independence, whether you're in a court or in a disciplinary hearing or whatever. You can't have two types of independence, one for court and one for commissions of inquiry. And then we say, generally and legally speaking, it should be self-evident that all the rights above invoke both the legitimate expectations of commissioner for procedural fairness and also affects the rights of the public. This is just an aside. Accordingly, at the appropriate stage, both sections 3 and 4 of PAJA will be of relevance. Rationality and the rule of law will also be at play and play a clear role. Okay, I don't want to get so much into legalese, but all we're saying there is that there are principles by which the state is bound to act. And it is self-evident that this commission is not just about the issues outlined in the terms of reference, but as the judge correctly pointed out earlier, it's really about all of us. It's a matter that affects the economy, the public, and it's a matter that is probably of the utmost public interest, because tax collection is at the heart of the existence of any nation. Then we deal with what we seek to happen finally. We say, in view of the above, the Commissioner of SARS seeks the following relief or rulings from you, Judge. One is a discontinuation of this commission, alternatively, a stay of its proceedings pending the outcome of the disciplinary inquiry. If I may pause there, again, when I make these examples, I don't want to be taken literally. So when I talk about lis pendens, it's obviously, I'm saying this is a situation akin to that. But in any event, the judge knows very well that one of the principles of lis pendens is that if there are those two proceedings, parallel proceedings, so to speak, then it is the later proceedings that are usually stayed. But obviously, that's a matter that's in the discretion of a court, and hopefully we will not get there. It might well be that for practical reasons, it's the other one that should be stayed, but that's a matter that can be debated at leisure at a later stage. The point remains that you cannot expect fairness when a person is facing two inquiries over the same subject matter, which might come to different results. And we also say that all the evidence of the past 3 days must be expunged from the record, as it was obtained under a huge cloud of unlawfulness and procedural unfairness, particularly in the absence of the person who has clearly become the dramatis persona of these proceedings, which are now being called the Moyane Commission, for good reason. We also ask for the recusal of Professor Katz as a member of the panel of commissioners, for the reasons outlined. And we also ask for an undertaking, this was rather contained in our letter, an undertaking that this commission will not entertain or hear evidence relating to any subject matter or issue which forms part of the disciplinary inquiry. The reasons for this have also been explained extensively. And 5, we ask for a directive that SARS must provide the necessary legal assistance to the Commissioner to exercise his rights, which have hitherto been violated at this Commission. And let me just pause there again. There's no doubt, Judge Nugent, that but for the suspension of Mr. Moyane, if your commission was, as it obviously is, about investigating into his tenure, 2014 to date, at SARS, if he was upstairs and working here, one of the people one would think or hope that you would want to hear from would have been him, because it is under him, under his stewardship, that all these allegations happen. The only reason we suspect that that was not done is because he's now suspended. Now, that suspension should be irrelevant for your purposes. It should not play any role in your mind. You should treat him as the commissioner of SARS, which is what he is, until such time that he is dismissed, which is unlikely to happen given the shambles of that other process. The assumption must be that he's presumed to be innocent, and that on any day now he might walk back into his office. So why should he be treated differently now, simply because he's suspended, than he would have been but for that suspension? Again, the unfairness of that approach, of looking at him with a jaundiced eye simply because of his suspension, and when he has not been found guilty of anything, and treating him differently, is blatant for all to see. And of course, the likes of Minister Gordhan come here, quite frankly, during a time where he should be minding public enterprises, and in a way which it's sponsored by the state. And yet Mr. Moyane must face 2 proceedings, all on his own against the mighty state of South Africa, its president, and the likes of Mr. Gordhan, who evidently hates him. We therefore humbly request to be furnished with reasons for any ruling made in response to our submissions. And we would like to really plead with this commission that it takes these concerns to heart, because they come from a place of pain. When, just imagine if it was you or your acquaintance or your son or your daughter whose name is bandied about on a daily basis on television and in newspapers without any opportunity to refute, and while in jeopardy of the same issues coming before a disciplinary inquiry. In this new dispensation, we need a bit of empathy, Judge, and empathy means putting yourself into someone else's shoes. So let's assume for a minute that all the terrible things that are being said here about Mr. Moyane are true. Let's assume. He's the worst manager. He ran a reign of terror. He fired 500 people, whatever. Let's just assume it's all true. That's not what we're addressing. We're addressing the fairness or otherwise of all those allegations being made against him without him having an opportunity to face his accusers. All these people who were allegedly tormented by Mr. Moyane must come here and say all these things while their tormentor is sitting and watching television and not able to answer for himself. If that is justice under this so-called New South Africa, well, then I don't know what justice means. That is an abuse of power. It's an abuse of justice. It's an abuse of the money of the state. It's an abuse of positions that people have acquired, which they use willy-nilly to wake up and just appoint a commission simply to whitewash and to glorify their own terms of office with lies and untruths. It cannot be allowed to continue, Judge. We really would like you to approach this from a position of impartiality, which we know you for, and to, as we say, to apply it with a little bit of empathy and an understanding of where we're coming from. This is an abuse. It's a sham. It's a farce. And it cannot be allowed to continue. If people want to indicate that they are now back in power in like the Hollywood-style encounter, which happened on the 15th of November, 2014, well, then they must use their own money. They mustn't use the taxpayers' money to glorify themselves or to run the country by remote control. So that, in a nutshell, is what we've come here for. Obviously, Commissioner Moyane is making these submissions so that it can be resolved, I wouldn't say amicably, but in good time before the damage which is being done here. Literally every minute this commission is sitting can go very far. Judge, I must just say thank you very much for giving us the hearing and giving us the opportunity. When we requested to come here, you did not hesitate to give us an opportunity. And again, I'm sure that was motivated by the knowledge that Mr. Moyane is obviously at the center of these proceedings. We will be ready to take any, if I may just check with my team if there's anything. Yes, no, we are in possession of certain forms of evidence to back up some of the claims that we make, but I think it would be more appropriate to supply that to the evidence leaders because I have not myself had time to look at it. And
do I see them all? How many
yes.
are there?
No, of course, yes. One. The first, the loose page document, Judge, let's start with the easy one. The loose page document simply outlines what I called the GDP, tax to GDP ratio. It's a table of all the years, starting from the Gordon years to the Moyane years, where you will see the improvements which followed from the operating model. The other one is evidence of some of the grotesque equipment which was used by the rogue unit to violate the rights of citizens. And I might mention, we will give it to the, no, Eric, we'll give it later to the evidence. No, they can look at it obviously now, but we'll make copies. Yes.
Make copies.
Yes. And I just wanted to say just that the so-called activities of the rogue unit, there is, I think we made that point, that we understand that there is a transcript of evidence given to Sikakane, the Sikakane Commission, under oath by persons who have come here under oath again and given different testimony. One of those versions must be lies, and we will also try as much as we can. Mr. Moyane, just to close off on this question of the rogue unit, if and when the time comes, will tell you that when he arrived at his office, he found the files of individual taxpayers, prominent politicians, prominent sports administrators, prominent business people, which he immediately dispatched to where they should be, because he did not think that in the SARS commissioner's office it would be proper to have files of prominent politicians. And so those are some of the abuses that he cleaned up and for which he has obviously become unpopular. Thank you.
Mr. Mpofu, let me just say at the beginning that I've heard a lot about pain in the last 3 days, and I will deal with all of that pain empathetically.
Thank you.
Whether it is your clients or witnesses who might be telling the truth or might not be telling the truth. So we've heard a lot about pain. But let me add this. You said, if you have a problem with me, you'll raise it in no uncertain terms.
Absolutely.
I think you have already.
No, I haven't.
Well, no, please let me finish
Okay.
now. I've listened to you without interruption.
Thank you, thank you.
I have never been called a kangaroo court before.
Yeah.
Now, you know that under the Commissions Act, it is an offence to disparage a commission.
Yes.
But let me tell you, Mr. Mpofu, I've got a thick skin. So don't worry about that. I wouldn't institute any prosecution for disparaging.
Yes.
But what does strike me as we went through this is how loose it is with the facts. And I'd like to just take you through this and just raise what seemed to me to be problems with the facts.
Thank you.
But the first thing I think that you don't understand, perhaps you've read the proclamation which established this commission, or perhaps you haven't. Let me read it to you. In terms of Section 84(2)(f) of the Constitution of the Republic of South Africa of 1996, I hereby appoint a Commission of Inquiry into Tax Administration and Governance by the South African Revenue Service, with the terms of reference attached hereto, and appoint the former Judge of the Supreme Court of Appeal, who has been discharged from active service, Honourable Mr. Justice Robert Nugent, as Commissioner, assisted by Mr. Michael Katz, Advocate Mabongi Masilo, and Mr. Voyo Dominic Kashler. Do you notice that who the Commission is? I am the Commissioner.
Yeah.
I am the Commission. I am assisted by those two. Now, throughout here, you've talked about, for example, Mr. Katz as being a member of the Commission. He's not a member of the Commission. I am the Commission solely. As you will see as well from the regulations also published under the hand of the President. So I think that that's an error that I'd like to just correct. And that is why I'm sitting alone today.
Yes.
No, you can answer anything.
At the
make
end.
make
Okay.
a note.
That's what I wanted to know, yeah.
Yes. Now, that's what we deal with, first of all, at paragraph 10, where you say that the panel of commissioners consists of retired Judge Robert Nugent, Professor Michael Katz, Mr. Kashler, and Advocate Masilo. As far as we go to paragraph 14.
1-4.
You have it?
Got it, 1-4, yes.
Yes. On the 28th of June 2018, Judge Nugent eventually confirmed that Commissioner Moyane would be given audience at 9:30 on the following day, the 29th, as per his request dated the 22nd of June. Now, that gives the impression it took me 6 days to give him this opportunity the day before today.
Yes.
Can we just go through the correspondence that has passed between us? I'm sure that your attorney has it. If he
I've
does-
got it in my head.
Right. On Wednesday, the 20th of June, 2018, at 9:33 in the morning, I sent a letter to Mr. Mabuza reading as follows. I understand you are the attorney of the Commissioner of the South African Revenue Service, Mr. T. Moyane. I write to inform you, for your information and as a courtesy to your client, that the Commission of Inquiry will be hearing evidence in public from 26 to 29 June 2018, commencing at 2 o'clock on 26 June 2018 at the following venue. That was responded to by your attorney on Friday, June the 22nd. I'm going to read the whole letter again. Thank you very much for your letter dated 20 June 2018, in which you advised Commissioner Moyane, as a courtesy, of the impending hearings of your Commission of Inquiry next week. Due inter alia to the short notice, it is not possible to attend the hearings in full. However, our client deems it necessary to request an opportunity to address the Commission hearings in order, inter alia, to place certain issues on the record and where necessary to seek certain rulings. Such issues include, but may not be limited to, raising an objection against the suitability of Professor Michael Katz, and I won't finish that paragraph. Secondly, seeking an undertaking from the Commission that it will stay clear of dealing with any issue which is the subject matter of the pending disputes which have been placed before the disciplinary inquiry chaired by Advocate Azar Barmesi, so as to avoid double jeopardy and manifest unfairness, expressing our client's interest in participating in and cooperating with your Commission and attending to the practical arrangements for doing so in his capacity as the current Commissioner of SARS. We would appreciate it if an arrangement can be reached for our client to make submissions in respect of the above issues, preferably on the 29th of June. Note the 29th of June, it is today, at your commencement time. I think there are two things one should note from this. Number one, your attorney asked on the 22nd of June for an opportunity to speak to us today. That is a week later. Now, that's the second thing, is you sought an opportunity not to give evidence, but to address these objections to us. There's no request here for evidence to be given. You note
No,
that?
there isn't. Nobody said there isn't.
Now, why do my papers always get mixed up? On the 23rd of June, which is the next day, I wrote to Mr. Mabuza as follows. I have noted the contents of your letter of Friday, 22 June 2018. Note that the hearings commence on Tuesday, the 26th, and not the 29th. You are invited to make any submissions on behalf of your client at 10:30 on Tuesday, the 26th, June, at the venue indicated in my earlier letter. You'll see I was under the impression there that your attorney had got the date wrong. He said it's 26th, not the 29th. That was replied to at 11:07 on Monday, June the 25th by your attorney. Thank you for your letter dated 23 June 2018, in which you invite us to make submissions at 10:30 on Tuesday, the 26th of June. Unfortunately, due to the short notice and our other pressing commitments, we will only be able to attend the hearings on the 29th of June 2018. All our clients' rights are reserved. Now, you'll note two things from this. Number one, your attorney chose to come and present your submissions today, which was after the evidence has been heard. Not before the evidence was heard, but after the evidence has been heard.
Chose.
And the reason, according to this letter, is that he had short notice. Well, a week is not particularly short notice to present representations on the three issues that I've mentioned. Should Professor Katz be here? Should I give an undertaking? And what will I can't remember the third one. A week is not long for that, Mr. Mfofu. You've been a counsel for a long time, and I was as well. We can do things like that in a day. Thirdly, one of the reasons for not doing that is that your attorney had other pressing commitments. Now, if your attorney feels he wishes to attend to his other pressing commitments rather than come here, he's welcome to do so, but don't blame me. There are also, by the way, 1,000 and more counsel at the bar, any one of whom, I'm sure, you would easily find one to come here. I'm sure that you are not available because I know that you're very busy, but there are many counsel who could come here. On the 25th of June at 11 o'clock in the morning, I wrote to Mr. Mabuza, I note your response. For the moment, will you anticipate that I will hear you at 9 o'clock on the 29th? But I will confirm that in the course of the week. I wasn't quite sure then what time we would be starting. The response is rather surprising. It's at 5:31 p.m. on June the 27th, which is 2 days before this was going to be heard. We refer to your email dated the 23rd of June 2018. We have made certain arrangements to make an appearance at the hearing on Friday at 9, as you indicated in your email, subject to confirmation. Your failure and/or delay to confirm at this late hour the time is prejudicial to us in that we need to prepare for such an appearance and to keep counsel available, which can obviously not be done overnight. Well, in my day, one could do it overnight, but things have changed now. But the point I make is that your attorney says it's prejudicial to you that you are told that you need to come half an hour later. Not half an hour earlier even, half an hour later, which gives you the extra half an hour. You'll understand the point. But that he says that my failure to confirm the time is prejudicial. Well, if half an hour is prejudicial, then it is prejudicial. But we must just get the facts correct. On the 28th of June at 6:58 a.m.
Sorry.
On 28th of June 2018 at 6:58 in the morning, Dear Mr. Mabuza, I wrote to him, my apology for the delay. You may advance submissions on behalf of your client on Friday morning, 29th of June. We will be commencing half an hour later than originally advised at 9:30. And that's where the correspondence ends. Now, I think I may be wrong, but you may wish to reconsider whether before paragraph 14, which reads, on the 28th of June, Judge Nugent eventually confirmed that he would be given an audience as per his request, might need to be amended to include what had happened before that. You might wish to just consider that. I'll leave it with you at the moment. Now, on paragraph 15, in the short space available, Commissioner Moyane consulted with his legal representatives in order to produce the submission, which had to be done overnight due to the enormously short notice. Now, I understand from that you must have done that last night. Now, you were told a week before that there'd be public hearings, on which date your attorney asked on the 22nd of June, a week ago, to be given a hearing. He was told the day after, that's 6 days, you are invited to make any submissions, yet the submissions were written overnight. Anyway, let's look at that. You see the difficulty I have with that paragraph?
No.
You don't see it? Okay, we'll come back, make a note. What Mr. Godin did not explain is how he came to be the first witness to be called. Well, Mr. Godin would not know that. I would know that, and the advocates assisting me would know that. How he happens to be in possession of documents, well, not sure that that's a particular big issue, but there it is. Now, thereafter, you give a lot of facts of what the true position is. And it might well be the true position, and it might not be the true position. But this commission will be continuing until the end of November. It is now 3 days into the hearing of evidence. There have been 2 or 3 weeks of inquiries made beforehand. Your client, if he wishes to have an opportunity to be heard, will be heard. You need have no concern on that score. We have until November for him to be heard. I see no reason why he should be heard now, but you will tell me why he should be heard now. And may I just suggest to you, you will of course advise him, but I suggest to you that it might be a lot more in the interest of your client to give evidence once he's heard everything that has been said against him and prepared properly, and he will then be able to respond to it. In my view, but it is not my view that will prevail, it is far more prejudicial to a witness to give evidence after each witness, not knowing what other evidence is coming. It is a very dangerous practice, as I found in my practice. You talk about what the media has reported, etc. A few examples are given. I don't choose what the media reports. The media must do its business, and I will do my business. If the media gets it wrong, if they embellish at times, if they give sensational headlines, well, that's up to them. And to tell you the truth, I hardly ever read the media and make a point of not doing so as far as possible when I'm in a case that is reported in the media. All this is occurring, you say, in a situation where Commissioner Moyane has not been invited to the Commission or been contacted by the evidence leaders, as appears to have been the case. Undoubtedly, he has not been contacted. This Commission was appointed 4 weeks ago. You will have seen from its terms of reference that they are extensive. There is no reason why Mr. Moyane should be the prime person to be spoken to first. We will speak to Mr. Moyane if he wishes to be spoken to, but we will speak to him when it is an appropriate time to do so. SARS is a very complex organization. To walk into SARS with terms of reference like this is a daunting task. To walk in and expect that within days or weeks one is familiar with how SARS operates is not possible. Nor is it possible to come to terms with these terms of reference, in which we are asked, incidentally, not only to look at SARS, but we are told that the Commission may request the advice or input of the South African Revenue Service, the Davis Tax Committee, the Office of the Tax Ombud, the Financial Intelligence Centre, the South African Reserve Bank. Now, if you want to know why the witnesses were called as they were called, let me tell you. Because it is no secret. I've told it to the press, the media, time and time again, and if you had been here, you would have heard it. If you look at these terms of reference and you say, well, these are huge, I've got until November to do it. That's what the President told me to do. I said I will do my very best, and I am intent on doing so. What one would do, or maybe not what one would do, what others may do it differently, but what I do, and it seems to me that the sensible way to go about, is to look at all these terms of reference and say, where do I start? Now, in Alice in Wonderland, they said you start at the beginning and go through to the end, but that's not the case here. If you look at the beginning of the terms of reference, we must inquire into the adequacy and legality of steps that SARS took or failed to take in the light of revenue shortfalls relative to the budgets, management of tax and customs settlements to ensure that the settlement process were not compromised, and so forth goes on. Well, that's no point to start. You first need to know about SARS, what is happening in SARS, and get an idea from which you can progress. And what do we know about an organization such as SARS? We know it is a large organization with 14,000 people in it. We know that an organization like this operates because of its people and its technology. Those are the two that go hand in hand. The first thing one must look at is its technology and its people before one is in a position even to start. And so one goes to what to me was the obvious starting point for our inquiries, and it is this. It's paragraph 1.6 of the Terms of Reference. With regard to the reports of the number of senior or experienced SARS employees that have left the employ of SARS since 2014, to inquire into the reasons why they left, whether any employees were coerced in any manner into resigning, whether any severance benefits were paid to those employees, whether there was any obligation to inform the Minister of Finance, etc. It's about employees who had left. And employees who were coerced, whether employees were coerced into any manner, into resigning. Well, the first port of call is to say which employees left or resigned during that 4-year period. And what one does then is one goes to the personnel files with some assistance, and you say, let me see the personnel files of the people who left or were left during that period. And one draws out of that the people that you're concerned with, starting from the top levels, which are the most important. And then one says, well, let me just have a brief talk to these people to get an idea of whether what they say is relevant to this or not. And that is what one does. Advocate Steinberg, Advocate CEO, spoke to some of them, reported to me, yes, they are relevant or not relevant, as the case may be, and suggested that these be called because they are relevant to that. Well, that's a good idea because it does two things. It helps to answer that one, those terms of reference, but in the course of doing so, one gets a better idea of the organization, the organogram, what people do, what kind of work is done, etc., which helps one then to get into the others about the organizational structure and so forth. Now, all of those that were identified as being in that category of having resigned or alleged to have, or alleged that they had been coerced to resign or leave for other reasons, were called, except for one. There was one woman who told a very strong and sad story. I said, will you go and give evidence? She said, I don't want to. I don't want to be in the public eye. I've had enough. I'm in pain. I don't want to do it. Well, I could have compelled her to come as well, but I wasn't going to compel anyone of that kind to come and give evidence. So the others that were called were those that fell into that category who had been defined as falling into those terms of reference. That's why those were called. Now, I've also found in life that one can build conspiracies, and the fewer facts you have, the more easy it is to build conspiracies. The more facts you have, the more difficult it is. It trammels you into what actually happened. But to build conspiracies requires few facts. And I suggest to you that when you're suggesting that there is some conspiracy about the witnesses were called, you might not have been aware of the facts that I've outlined to you, which might have influenced what you said, and you might have not said the same thing. But I just leave that with you as well. Now, where are we? I quite agree with you. Fairness is a cornerstone. I think my life on the bench, I've never been told to be unfair. You can tell me if I have. You know me very well.
That I know.
In fact, you were my junior when I was an advocate.
I know.
Yes.
And you are very fair.
And in fact, you sat with me as an assessor on the labour courts. Do you remember that? We were all a lot younger than Mr.
We were.
But time goes on, but you'll remember those. Now,
Thank you.
I don't think you ever said I was unfair when we heard cases in the labour court. I never heard you say when we ran cases and you were my junior, look, you're acting unfairly. But let me tell you this, we can all do it. We get a sense of what we think is fair, which may not be shared by others. So I appreciate that fact, that others may see it differently. But when you look at fairness, as you know from all the cases, you've got to look at the particular situation you're faced with, and you say, in that situation, what would the fair thing be to be? To me, it was perfectly fair to call those witnesses as a bunch, hear what all of them said, and then allow your client, if he wanted to look at their evidence, examine it, and then decide where to. So that was my idea. That your client would have an opportunity to deal with. We've got until November. There was never any doubt in my mind. But let me add as well, I won't compel your client to give evidence. It's his choice. He must be informed, he will make a choice, and if he wants to, he will give evidence. And we can arrange that, as I've arranged with Mr. Mkwakwa, who is coming to see me next week to discuss what is the best way for him to do so. So that really deals with how it came about that these witnesses were called. Now, paragraph 26. Part of the unfairness is the failure to invite the Commissioner. I didn't invite anyone sitting in this room. I told them that it is a public hearing, and by implication, a public hearing means anyone can attend. And your client is also part of the public, and he was free to attend. He chose not to attend, despite being told that, and he said, we've got other business. His attorney said, we've got other business we need to attend to, but we'll come on Friday. Eliciting evidence adverse to Commissioner Moyane's rights without giving him an opportunity to rebut the same. He will have the opportunity to rebut the same, but it is 3 days into the hearings, and we have until March, till November. Choice of witnesses, I've dealt with that. Facing 2 inquiries by the same person. There are not 2 inquiries by the same person. Advocate Bam is doing his work, and he will be left to do his work, and I'm doing this work. There are not 2 inquiries by the same person. Now, you've handed to me you've told me a lot of facts, and I hope and I will invite you, Mr. Mpofu, to bring evidence in support of those facts. You heard me this morning say to the media, and I've said it a number of times, anybody who has any evidence that is relevant to this inquiry or any submissions they make, please bring it forward. I appeal to them so it can come forward as soon as possible so we can get our work done without ending up trying to finish it, put it in at the last moment in November. Now, so all of this, I mean, these facts, the press can repeat them if they want to. That's not my business. But as far as you've given me a memory stick, I don't want this memory stick. Give it to me if and when your client gives evidence. For the rest, give it to the press as far as I'm concerned. Let them publish the whole lot. I'm indifferent to that. I will do my work and they will do their work. So here is your memory stick. You can give it to the press. Now, you say as part of the unfairness, it has been established that these characters refused to testify before the ongoing KPMG inquiry chaired by Advocate Nsebeza on the grounds that they are still facing a criminal prosecution. They have, however, been keen to testify before this particular inquiry for obvious reasons. I'm not sure how obvious they are. Perhaps they were willing to do so because it's the first time in 4 years, according to some of them, that they've had a chance to have their say. That might be the reason. But don't forget, Advocate Nsebeza has no powers of compulsion. All of these witnesses were told that if necessary, I will compel them to give evidence. They didn't have a free choice. They had a choice to do so under the threat that if I thought it was relevant, they would be compelled to come here. You say they were keen to Russia to be dealt with as sweetheart evidence. Well, don't talk to Advocate Steinberg. It didn't look like very sweetheart to me. And you say in paragraph 35, the witness list makes very interesting and curious reading. It suggests that there was an earlier evidence gathering stage to determine the alleged relevance of the evidence, and also some witness preparation. Let me tell you as far as witness preparation is concerned, I specifically instructed counsel, you do not prepare the witness. But in every commission of inquiry, One makes inquiry, or one interviews the witnesses to see if they're going to contribute anything. You don't call witnesses not knowing what they're going to say. Otherwise, I mean, you spend there are 14,000 people in this organization. Do you think I'm going to call 14,000 people and say, do you know anything about any of these things? We interviewed witnesses selected by reference to the term of reference, and they were interviewed to see if what they said would be relevant in the sense that, that they were going to tell us anything about what we were going to find. So it does make interesting reading the witness list. It is interesting because those are the people that fell within the terms of reference. The hostility of the principal witness and architect of this process, Mr. Gordon, towards Commissioner Moyane, is so well known that the Commission would be hard-pressed to deny knowledge thereof. Quite frankly, I don't know about this relation. I know nothing about handshaking or not handshaking. I don't read the newspapers a lot. I have read from time to time that Mr. Gordon and Mr. Moyane are in some conflict. I don't read it. I'm not interested. You know what I do, Mr. Mpofu? I grow vegetables.
Good luck to you.
I assure you it requires a lot of luck, very difficult. But that's what I do in my, that's my day job. This is an extra job. My day job is I grow vegetables, I read books and so forth. I don't read the papers. My wife brings them home, and I said, don't bring them home. I don't want to hear about the troubles in this country. I want to grow my vegetables. The choice of witnesses also exhibits that the Commission has prejudged the issues before it and is merely going through the motions to reach a predetermined outcome. This is patently unlawful. Of course it would be unlawful if the matter has been prejudged. You've seen a judgment written by me, because I'm sure you read all the judgments. It says the following: to instruct people who have to hear and decide issues. They must keep an open mind. But it also says an open mind is not the same as a blank mind. One hears the evidence, it makes an impression on you in one way or the other at that time, but you don't know. You say, well, that looks impressive or it doesn't, etc., as you know when you sat with me in the Labour Court. But what you also do is you say, but hang on, let me wait. Let's hear the other side. Let's hear if there is another side, by the way. And if there is another side, one listens to that, it makes an impression upon you, and at the end of the day, you sit down, you take the two, you look at what was said, you ignore what the media has said about it, which I don't read anyway. You ignore that, you look at the facts that have been given, the evidence that has been given, and you weigh it up against one another and say, which one do I believe? Now, that is what I've been doing for 20 years, and I'm going to do the same here. Now, now let's go to the two separate tribunals. Look, I didn't appoint any of these tribunals. The President did. I have no idea why he appointed the two. The President, office phoned and said, will you constitute this commission of inquiry? I said, send me the terms of reference. I looked at them and said, yes, I will. I did because I thought I'll leave my gardening and get back into public life and see if I can do something that is useful. I don't know why there are two separate tribunals, and I'm not interested. I have read, I think, in the newspaper that affidavits have been filed in the other matter. I have no idea even when they're going to be answered or whether there's a date or whatever. I will get on with the work because a proclamation has said, and I've accepted that appointment, you must do this work and do it by November. And I will do that, and if Advocate Baum's matter has got nothing to do with me. You say in 40.2, it is a trite principle of the common law rules of fairness and justice that a person cannot be tried twice for the same offence. There is no offence alleged here. We are not trying anyone for any offence. Any decision we made, unlike the decisions I made for 20 years, which had consequences. People went to jail, they had to pay money or whatever. There is no decision being made by me with the assistance of assistance. We are finding facts to report to the President. What he does with them is his business and not mine. There is no finding of fact. I might get the facts wrong, and the President might act upon them. Well, if I get them wrong and he acts upon them, the President can blame me, but I'm not. There's no offence committed here. I've said a number of times to the people who have been here, this is not a trial. This is not an adversary process. This is an inquiry. An inquiry means you inquire into what the facts are. I am keen to do so because I've been told to do so and because I think it is in the interest of the country that facts be brought to light. You say the overlaps between the two inquiries are self-evident. It is indeed so, this is 41, that in addition, one of the two reasons originally cited by the President for his alleged loss of confidence, namely the VAT refunds, miraculously did not appear in the charge sheet. Well, what is the problem with the VAT refunds, by the way, is this. As I understand it, we haven't inquired too much. Businesses have been complaining to the Ombudsman for a long time. They say our VAT refunds are not being paid. Why that is so is one of the questions that we ask. Why are these VAT refunds not being paid? The little I've been told about it thus far is they say, look, it's important that these VAT refunds be paid because it is money back into the economy which generates more money, which attracts more tax and so forth. That is what they're concerned with. They're concerned that business is complaining. Of course it wouldn't be in the chart sheet. I wouldn't imagine it would, but I mean, I didn't draw the chart sheet. They can put in it what they like. I've dealt in 42 with the kangaroo court. As you say in 43, and the mistake that is made there, you give an assumption. Assume this commission finds Mr. Moyane innocent or guilty as the... We're not here to find whether he's innocent or guilty. We're here to find the facts. And just on that point, you say this is known as the Moyane inquiry. Well, I haven't heard it referred to that, but maybe the press are referring to that. As far as I'm concerned, and I've asked people, this is to be called the SARS inquiry. They say to me, look, we can't dictate to the press, and I say, of course you can't. But as far as I'm concerned, I would prefer it to be known as the SARS inquiry. If people are calling it the Moyane inquiry, then they're quite wrong. This is not an inquiry into Mr. Moyane. It coincides with the time that he's the commissioner, obviously. Now, in that sense, Mr. Moyane, he was the commissioner during that period, and some of the things that we are hearing about and might find, of course they were done under his watch, and they will come back to home for him. That is the nature of being a commissioner, someone at the top. Things that happen in your organization come back to you because you are the boss. So far as it is a Moyane inquiry, it is not a Moyane inquiry. I acknowledge freely that a lot of the evidence will refer to Mr. Moyane as it has already. Now, bias, well, I think I've dealt with that. Now let me turn to Professor Katz. I asked Professor Katz when I got the first letter from Mr. Babuza. I said, I phoned Mr. Katz and I said, Professor Katz, will you do a favour for me? It is alleged that you are friendly with the President and his lawyer and so forth. Will you just write for me a letter? Don't comment on it. Write for me the facts of your relationship with Mr. Ramaphosa. Well, he wrote that for me. I'll give you a copy. This is what he says are the facts. Let me read it to you. Dear Judge Nugent, as requested by you, the information you have sought is set out hereunder. On 11 and 12 August 2014, ENS Africa represented Mr. Cyril Ramaphosa, who was then Deputy President, at the Farlam Commission of Inquiry investigating the events at Marikana. The ENS team consisted of Michael Katz, Sue Hayes, Head of Litigation, and Kabwela Chisaka, an Associate. ENS briefed Advocate David Untholder. After the report handed down by Judge Farlam, which did not find then Deputy President Ramaphosa guilty, legal proceedings were instituted against a number of parties, including then Deputy President Ramaphosa. The proceedings commenced with a summons. The litigation department of ENS, conducted by one of our partners, Doug Malepo, is representing President Ramaphosa. Salient features of those proceedings are set out in a schedule prepared by Mr. Lokwa. That is Professor Katz's account of his relationship with Mr. Lokwa. I don't know if it's correct or not. Maybe that he visits his home for all I know. You've given no evidence that he visits his home. You just state it as a fact. I don't know if it's true or not, nor would I think do you. If you had known it was correct, you would have said so, and said why. So I'm not sure that you can be said to be his personal lawyer. And you go on to say the president could have done things another way. Well, the president must do what presidents do. He's chosen this way, and this is the way we will continue until such time as the president says, I don't want you to do it anymore. Now, the principle underlying this particular objection, that's against Mr. Katz, is nemo judex in causa sua. No one should be a judge in his or her own cause. Mr. Katz does not have a cause here. Professor Katz, to me, I'm very glad he was appointed, by the way. Professor Katz is deeply involved, probably more than anyone else in this country, although Judge Dennis Davis will probably deny it, in tax administration and tax governance. In the early 90s, Professor Katz chaired the Katz Commission of Inquiry. It went on for a long time. There were many recommendations made. If you'd read the report, I've read part of it. It's too complex for me in parts. But if you read the report, you'll see that it is a major study on tax governance and in a revenue office. Now, if you're asked to inquire into, as we are, and make recommendations on tax governance structures, who would one go to get the best advice? I would go to Professor Katz. He is the expert in the field. But let me tell you, you may think differently, and maybe he shouldn't have been appointed, etc., but let me tell you my difficulty. I didn't appoint Professor Katz. The President did. There is a proclamation that says that Professor Katz is an assistant to this commission. And if the President says that in a proclamation, then Professor Katz is an assistant. I can't tell Mr. Katz to go. I must say at times I wouldn't mind if I could. But I can't tell him to go. This should be addressed to the President. Say to the President, please take Mr. Katz out of that, Professor Katz out of that commission, but I regret to say I can't even think of doing anything. I don't have the power to do so. Now, I've spoken on a lot of things. Just to put some of these things in proper context and see why things have been done, and to add some facts. As I said at the beginning, conspiracies become easier and easier. I've seen it in the courts over and over. Conspiracies are easier and easier to construct the fewer facts you have. They become more difficult once you have more facts and more facts. They become more difficult. I would like you to just, these are other facts that I'm suggesting. And now, if you don't mind, we're going to adjourn for a short while so I can have a cup of tea. Is that okay?
Yes, no, you can have a cup of tea, but will I have an
What do you want to
opportunity
reply?
to respond?
No. What do you want to respond to?
No, of course. You've made all sorts of...
I'm not having arguments.
No, it's not argument, but I simply want to make submissions
If you want,
on behalf of
I
the
don't want
client.
submissions. If you want to add any facts, then add the facts.
Yes, I would like to.
If you want to
And
add
I'd like to address some of the misstatements and misunderstandings of what I was proposing here.
No,
All
I've
this
read
is
it.
very interesting, Judge Nugent, but I've raised only two issues really, which is it fair or is it not fair to have Mr. Moyane facing two inquiries? You say it's got nothing to do with you. I will demonstrate that it has a lot to do with you. The second one is whether Professor Katz, even with this letter, is somebody who should sit here, and again you say that you don't have the power. I'll show you that you do have the power.
Okay, that's fine. On those two issues, I'll certainly hear it, because I'm not making any rulings. I'm simply adding other facts.
No, I accept
I haven't
it.
made any ruling. I've made no decision. I have an open mind, but not a blank mind.
Yes, no, I know that, but I want to address some of the issues you've raised. That's all I'm saying.
If you would like to address those two
yes.
issues, and we can go back.
No,
to
not
them.
just those two issues.
Professor Katz.
You've raised about 20 issues.
No, I haven't
I'd like
raised-
to address some of them.
Okay, Mr.
Yeah, because, you know,
Mr. Mpofu.
other people might say.
Mr. Mpofu.
Yes.
Let me just ask you, just give me a moment to say something. You can address those two issues when we've had a cup of tea. You're welcome to. I have told you that as far as those two issues are concerned, my problem is this, and you will address that in particular. I did not appoint Professor Katz.
Yeah.
If there is a proclamation that says Professor Katz must assist us in this, tell me on what basis I can say, no, you don't.
But that's what I'm proposing to
I
tell you.
understand. Let's just say get clarity as I have my cup of
I'll
tea.
give you the clarity.
And the second thing that you are concerned about is the disciplinary inquiry. That was established under a separate proclamation. Am I in a position to say I will not continue with what I've been instructed to do under this proclamation because there is no one? What power do I have to do that? I've been appointed. I must do the job that is headed. So they're the same
I've
point
heard
in
you,
both
I've
cases.
heard you, Judge Newton. The question is whether I must respond now or after your cup of tea.
I'd like a cup of tea first.
Thank you.
No surprises.
Starts with the New York Times, but he doesn't read the paper. Hi. City Press. Oh yes. Hi. Hello. Thank you. Thank you. Yeah. 083. Oh sure. 260. I wanted to go all over the country. One minute.
We heard Judge when I spoke to him on the side, he didn't what's strict instruction that will come out as a result of the requirement by the end. Third, also, I don't know if there will be ongoing continuously up until such a time when the inquiry comes to an end. I'm guessing maybe, well, I don't want anyone guessing who said I have no, but we will just when once we get to it, of course, this is the last day of this procedure, the sort of day, but of course there will be ongoing. Of course, at the time we are has been applied to make some changes.
Otherwise, I'll be making a submission.
But the instinct is to defend it.
Exactly.
Mr. Mpofu, allow me to say two more things.
Of course.
I think you must understand that I know the role of an advocate is to present his client's case as best he could. And I've been around a long time. You act on your client's instructions, and it's right that an advocate should act on his instructions. It gives your client an opportunity to be in a court which he's entitled to and to have representation, and I have a very strong view that an advocate must act on his instructions. I mean, there is a limit, but that's not my concern at all. And I just want to make an invitation to your client now. He is welcome to come and see me at any time he wishes. He's welcome to make whatever submissions he wishes in writing. He will be asked in due course if he wants to give oral evidence. He is welcome to go and see the evidence leaders at any time. And we invite him to do so specifically if he wishes to raise any issues that concern him. Now, I think, Mr. Mpofu, we can get back to the two issues that were raised at the beginning. Just give me one moment, because I will give you some guidance. If you can go back to the two issues that were raised in the beginning in that letter, which is the position of Professor Katz and the other hearing. I mean, I think you make a fair point on both of those. Whether you're right or not is another matter. Of course, one must ask whether Professor Katz should be making any findings at all that go to the President if he has an association with the President. I've told you what he says his association is, but the question, even on that association, the question is a fair one to ask, should he be on this commission? And the second one is the disciplinary proceedings. I confess it concerned me a little bit. You've asked for an undertaking from us that we won't touch on things there. I'm very sensitive to the fact that it's not an enviable position to be in, where you're facing the possibility of having to deal with issues on two levels. And I have asked myself about that, with that sensitivity in mind. What you could address as well is whether a commission, whether I'm entitled to give you an undertaking that we won't do that. In other words, given my terms of reference, must I just carry them out? Is this a matter to take up with the President? Isn't the right place to take it up with me? And secondly, though, whether a commission should ever give an undertaking that it will trammel its inquiry for any reason at all. So I'd like you to deal with that. I do wish to say, though, that there are many issues in our terms of reference. I think I saw that the so-called charge sheet against your client. I think there were 4 charges, if I remember correctly. I don't see ourselves getting to a position where we will necessarily touch on those, bearing in mind how many things we need to deal with and the length of time we have. So what I can say to you is that I will certainly try and avoid it, because I think it is the best thing to do to try and avoid it, whether I'm obliged to or not. But we've got other work to do, and I certainly will try and avoid it. The question is only, am I entitled to give such an undertaking, which I'll consider. So perhaps you can address me on those 2 issues.
Thank you very much, Judge Nugent.
By the way, I'm also grateful that you said that you don't doubt my impartiality.
No, never will, never have. And I'm also happy that it looks like that cup of tea did some some good. Well, Judge Nugent, I must say that the remarks that you've made now assist a lot to limit the issues. And all I can say is that you say the question of facing 2 inquiries concerned you a little bit. Well, the only difference between you and me and my client is that it concerns Mr. Moyane a lot.
I understand.
So it's a question
I understand that entirely.
Yes. No, I
understand.
I appreciate, yes. Judge Nugent, let me just say this. Firstly, I'm also glad that you accept that I'm not doubting your standing at all. That I would never do. I come a long way with you, and in the SCA and everywhere. So that I must repeat is not the issue. As you know me very well, that if it was an issue, it would be put on the table. But I have to say this, that 2 things about your vegetable growing activities. Well, I appreciate that you grow vegetables. Some of us would also like to grow vegetables, but we don't have the land.
Mr. Mpofu, I think we should not go any wider than we need.
No, let's leave it there. Thank you. No, that was on a lighter note.
Yes, it is.
But what you have said is that you are not aware of what is in the newspapers, which is a good thing, by the way. Sometimes I wish I was not so addicted to reading newspapers.
Of course, I've become I see some things from time to time,
Yes,
but
no,
I
of
don't
course.
particularly read these things.
Yes. So, well, the problem with that, of course, as far as my client pointed out, is that when you started for the off, so it looks like you do read some newspapers now and again between the vegetable growing.
When someone sends it to me on the email and says, please
Yes.
read this, then I read it.
Okay, anyway, be that as it may, all we want to say really is that, Judge Nugent, this is not, and I'll say this in all sincerity, it's not about you.
Yes, sir.
And it's so we don't want you to adopt the stance as if you are opposing counsel and deal with each point adversarial team, because it's really not about you. And we appreciate the differences between your powers and the powers of the president at different levels. So I think that was maybe the fundamental misunderstanding. You've been appointed to do a job. Some of these things might fall under your peer review, some might not. And it might even be arguable which ones do. So we don't want to start from the wrong premise that this is about you. Let me just make one example. You say, our complaint is very simple. We are saying, and you correctly say that Mr. Moyane is the boss. This is about his tenure, really. And yet, he has been treated differently. Would dare say almost discriminated in relation to other witnesses. Why do I say that? You made an example. You say you spoke to a woman who told you a sad story, and you had to debate whether you must call that woman or not. Well, when are you going to hear the sad story of Mr. Moyane? All those people that you spoke to earlier have obviously been invited by somebody for you to hear their sad stories. They've had to give an account, and then a decision was made as to whether or not they're going to be called. I'm just making that as an example of the gist of our complaint is exactly that. It's not against you. Probably that's not your job either. It's maybe the job of the evidence leaders. That's why we're saying the whole affair needs to be looked at. And at different points, the answers might deal with different people. You talk about conspiracies. It's not a conspiracy. It's a fact that Mr. Moyane was not called here. It's a fact that he was told, and I'll get into that, only yesterday as to when he should come here. It's a fact that Professor Katz is Mr. Ramaphosa's personal lawyer, whatever is said or not said in that letter. And I don't want to be party to this or testify, but everyone knows that Mr. Katz is Mr. Ramaphosa's personal lawyer. It's between him and his conscience as to what he discloses to you or doesn't disclose to you. So it's got nothing to do with conspiracies. It's a fact that Mr. Moyane is still the commissioner of SARS as we speak now. That's a fact. It's not a conspiracy. It's a fact that he's at the head of this organization, and he should therefore be consulted. And it's a fact that he's facing another inquiry, and you correctly say it's a matter of some concern, maybe not on your table, but it should be a matter of concern to any fair-minded South African. A category on which I count you as being part of.
I don't like to interrupt you, but you're repeating things that were said. I'm taking these. I'm not giving any decision right now.
Yes.
I will read them again carefully, and I think you are repeating a bit of the things.
Yes, no, I'll try to.
Do you think we can go to those two issues that worry me most, which is just what my powers are on the two issues?
Yes, yes. No, I'm getting there very, very quickly. And thank you for the, how to call it, memory stick and the advice that we should give it to the media. Maybe
no, I didn't advise that you should. I said if you wish to, you can.
Yes. Well, we'll ask the client.
Please, we must get this accurate.
Yes.
My attitude to the memory stick is this. If you wish to produce it as evidence before it, well, then introduce it. You're welcome to.
In due
I
course.
invite you to, but I'm not accepting it now as sort of evidence somewhere in this argument about Mr. Katz and the undertaking.
Yes.
You see.
Okay. No, fair enough. But that attitude betrays not appreciating what it is that we are complaining about. It is of no use for you to assure us that one day, maybe in November, Mr. Moyane might have a chance to have his say. That is not what we are complaining about. That is so obvious that it doesn't need to be stated. If he wants to give evidence, he will do so. The point we are making is about rebuttal. I don't know if it's appreciated. You can't say to somebody comes here and talks about you and castigates you and say all these things for months on end. No, don't worry. In November, you'll have your say.
No, please.
You should have a right to rebut
Sorry.
at the time that
Mr.
you are being
Mpofu,
disparaged.
please.
I'm sorry,
I
Judge.
didn't say that he will have his chance in November. I said we have until November.
Yes.
I've invited Mr. Moyane. He can come next week to talk about it, and your attorney, about giving evidence, submissions. I've invited him specifically to come and talk about it. We won't be sitting until August again. That'll give you 4 weeks. Prepare properly if you want to, etc. If he wants to give evidence in August, we'll talk about that. But
Yes.
please, I did not say he must wait till November.
Okay, no, fair enough. But there seems to be a misunderstanding of what you wrote to my attorney, or maybe what I was submitting. Maybe I didn't articulate it properly. You wrote the following to my attorney on the 25th of June. Dear Mr. Mabuza, I note your response. For the moment, you will anticipate that I will hear you at 9 on 29, but I will confirm that in the course of the week. Now, you seem to suggest that what you're saying here was about the time, whether it's 9 or 9:30. No, you were saying you anticipate that he'll be called at 9 o'clock on the 29th. So the whole thing, you will be confirmed in the course of the week. So we sat there not knowing, are we coming or are we not coming? It's got nothing to do with 9 or 9:30. It was whether are we going to be invited, as we're sitting in anticipation, as you invited us to hear whether we'll be heard at 9 on the 29th. Only yesterday did you, that's why we sent that. We would not have sent that letter just to check whether it's 9 or 9:30. We said to you, we are sitting here, we have other things to do. We would like to know, are we still invited at 9 o'clock on the 29th? So it's both aspects, which I think you misunderstood completely, or rather we misunderstood your letter, because the letter makes it very clear. So this idea that we're sitting for a week and all that must just be thrown out of the window. It's only yesterday that once it was confirmed, and that's what we talk about overnight. Of course, you are right that people work overnight, council has to, but it's not something that must be done just for the sake of it. And therefore, due to our reading of your letter, and we know it's not a judgment. It's a letter which you are a 1 or 2 sentence letter, but we understood it like that. Now, you also say that when we say the same person, 2 inquiries by the same person, another misunderstanding. We don't mean you or a BAM SC. We mean inquiries by the same person, namely the president. This inquiry is established by the same person as the other one. So again, we need to clarify that. And you say you're not interested in the activities of Professor Katz. We take the point that he's not a commissioner, but that doesn't take the matter any further. He is part of the decision-making of this body. As your advisor or anything, I'm quite sure, knowing you, that you would not want to have an advisor who is compromised in this matter. Assume for a minute that he was. So it doesn't matter the semantics about whether he's a commissioner or an advisor. The point of the matter is that he's a decision maker and will have some influence, adverse or favorable, to the outcome of this body here. And please, if you know, like you, I know Professor Kurtz is one of the nicest people I know, and I have no doubt about his competency. So again, this is not some personal attack on him. And as you correctly say, we act on instructions. One issue that I have to say, for his sake maybe than others, is that this has absolutely nothing to do with what you tell us about his expertise and that he was deeply involved in tax administration of the country. That we don't doubt at all. He's probably the foremost qualified person to deal with this matter. But that does not address our concern. You can be the most competent person or judge or human being, but if you are conflicted, you are conflicted. You can't simply say, well, you are the most, you are this special being. We accept his credentials, but we're simply saying, despite those credentials, he can't act in his own cause, so to speak. And we use that word, broadly speaking, simply to suggest that he has revealed to you more or less about his relationship than the history will show at the appropriate stage. So again, this is something that, let me make an example. If
I understand, I take your
yes,
point. I
thank
actually
you.
do take it.
Thank you, yes. So if we
Whether or
can,
not it's you're a
in your
competent
purview.
person doesn't mean you're not conflicted.
Absolutely, yes. And we'll make a simple point that if we came here and said, you know what, Judge Nugent, one of your assistants is Mr. Moyane's uncle or something like that, and therefore they will not be able to put an impartial mind to this. Surely your response cannot be, it's got nothing to do with me, because those people are your assistants. It's up to you to decide whether you want to be assisted by a tainted person or not. Yes, of course, the person was appointed by the president, and the president might have to answer for his, the conflict, by the way, is not with you, it's with the president. But the point is that on a limited basis, it's your baby, I'm sorry, because you are the person who will sitting with that panel. You are entitled to say, I will not have a panel of assistants or evidence leaders or anybody who is compromised in the issues. Again, I'm saying assume for a minute that he is, which he might not be. So it's a conceptual fine line which must be appreciated. So it does have something to do with you, I'm afraid. And obviously you'll pronounce one way or the other. The other thing is that there are 14,000 employees. Well, only one of them is the CEO and the head. And that's what we're talking about. We're not suggesting that you must call all the employees, the 14,000 employees. Now, just to round off, the central issue here, which we argue, rightly or wrongly, falls under your purview, is whether it is fair. You can't put higher than that. It is fair that Mr. Moyane, or unfair that Mr. Moyane should be subjected by the same president to 2 inquiries about his the governance under him in this institution. That question you might answer, or it might be answered elsewhere. But our view is that it is not fair. The second one is whether it is fair or not that statements must be made in the absence of Mr. Moyane without his right to rebut those statements at the time, not sometime in the future. Whether it's November or October, it doesn't matter. The point is, do we have a right instantaneously to rebut the some of the lies that have been told here? Or should we wait, excuse me, on the assumption that other South Africans do read newspapers and don't grow vegetables in their spare time? Should we wait until that damage is done and the complaint should only be raised at that stage? Again, you might have a view on that or you might not. But the reason why we ask you for a ruling is so that if and when we complain to the president, as you correctly suggest, about some of the issues, or anywhere else for that matter, we don't want someone to say, you should have raised that with the commission, or you should have raised that with Judge Nugent. That's what we're doing now. We're raising it here. We'll get a ruling. A ruling doesn't have to be articulated. For example, if you say you must not continue, if you continue, that's a ruling, clearly, because it would mean you have adopted a particular attitude. So that's really all we're doing this morning. We don't want to fight with you. We don't want, there's no need for being defensive or for tempers to rise. We're all doing what we can under the circumstances. And it's certainly not about you or anybody else that is who's being attacked by us. And the right of rebuttal, when I was your junior, I'm quite sure you would have appreciated that the right of rebuttal must be exercised at the time, not at some postponed date. And the point is this, let's say we come in October, September, whatever. The point is, at that time, if the BAM inquiry is still continuing, which it might be, then as I illustrated, there might come a time where we are expected to come here and literally go and answer about the same thing down the road. And that, I'm afraid, will need to be understood as the mischief or the fear of what we want to prevent. Right. So I've addressed the question of the short notice, and I've also addressed your concerns about or rather your issues about Professor Katz. If I can just look through my notes. Yes. Oh, I've also said that, yeah, we don't accept your statement that your hands are tied in these matters with the example that I've just made. But if that's your ruling, that's your ruling. Yes, we appreciate the invitation that you have now given us, and obviously a client will have to consider it, given the constraints of the double jeopardy that he faces. And yes, I'm reminded simply to say that the evidence, such as what you might call it, of Mr. Godin is available if you need it, and you have said that you did not choose the witnesses. It's witnesses who are covered by the terms of reference. and we would like to ask you which terms of reference cover Mr. Gordhan, because he's the Minister of Public Enterprises. And quite frankly, he has no reason to be a busybody when the public enterprises are burning.
Would you like an answer to that now?
Well, I would appreciate it.
Let me give it to you right now.
Yes.
See, in the terms of reference which I've referred to is that we're dealing with a period of 4 years from the 1st of April 2014. And one of the questions is, why did people leave? Now, nothing happens in a vacuum. History tells you things. You've got to see things in their historical context. And what we asked from Mr. Gordhan is to understand what the position is in which people were working in April. I don't think one
2014,
can...
yes.
April 14. I don't think one can understand people's explanation of why they left unless one understands why they were there in the first place.
Yeah.
And that's the reason. It's
No,
as simple as that. It's to establish historically so that one could go beyond that and then say, well, that was how they saw things in April. That was the system at the time. And when they say, look, I left because of the change of system or whatever, one understands then to what extent the system change led them to leave, or to what extent were they coerced to leave. What was the reason for them leaving? We can see that properly, only in its historical context.
Yes.
So that's the reasoning.
No, thank you. Well, it isn't. Thank you. No, we understand that. But our gripe really is quite simple. It's all very well to know the history, which everyone must know the history. But this commission, we thought, is about the present. In other words, you can trace the history, but your core business, according to the terms of reference, is the period between 2014 and 2019.
2018.
2018, yes. At which time, I'm sorry, I'm thinking about the full term of Mr. Moyane, so that when he comes back, he knows when he must finish. 2019. No, no. We appreciate that point, but our repose is very simple. The core issue is about Mr. Moyane. So before anybody goes and asks Mr. Gordhan to do a 140-page presentation, maybe the same invitation should have been extended to Mr. Moyane, who actually was the SARS commissioner.
Sorry, I didn't ask him for a 140-page presentation. We asked him to come and give evidence to explain what structure he set up. If he arrives with a presentation and he wants to give it, well, that's what he chose. He wasn't asked to present 140 pages.
Yes. No, but the point is Mr. Moyane was not asked to present even one page or anything.
Yes. I understand that point.
That's the point we're making. And so look, I think that it's the unfairness of the situation speak for itself. It's either it is appreciated or it's not appreciated. We have made our submissions. I appreciate that you will come back to us in due course. I can understand that you have other things to do. And by the way, my attorney, when he said he's got other matters, he was not referring to me. He was simply saying that
Yes.
he can't be expected to work on a 24-hour cycle for something so important. In his defense, it was not about availability of counsel. So what are we saying? We would like you to then give us a response, formal or otherwise, at some stage, and we will consider our options at that stage. But we note the invitation.
Thank you, Mr. Mpofu.
Thank you very much.
I will give you a ruling on Monday at 2 o'clock.
2 o'clock. Thank you very much.
I just want to inform you that we have the witness we want to call today and listen to. You'll recall that it is said somewhere that there was a 50 billion rand shortfall in revenue collection.
Yes.
Now there is a debate as to what caused that. Was it the economic downturn? Was it the way SARS was going about collecting taxes? We had asked, and I hope I don't offend you when I say a number cruncher from the Treasury to come to look at that and tell us whether the figures of revenue collection and the economy or whatever could tell us anything about that question of whether or not,
Yes.
why there was a shortfall. Does it tell us it was the economy going down, or does it tell us that it was SARS not collecting? He's prepared that, and we're going to continue with that evidence. Your client is welcome to stay and listen to that evidence.
Thank you. Yeah, no, we will consider that. If we are not here by some chance, the only issue is what we've raised in our document, which is simply that there's a structure called ROC, R-O-C, I forget now what it stands for. You can put it to your expert, which determines the revision of tax forecast. So that's why we're saying it's a misunderstanding to think that it's only about SARS. The ROC is made up of the Reserve Bank, SARS, and Treasury. Oh, here's the name. It's a Revenue Analysis Committee.
The Revenue Analysis Committee, and just tell me what I should alert him to on that.
Yes, that whether he can confirm that
revenue and
it's called the Revenue Analysis Committee.
the Revenue Analysis Committee.
Committee, yes, and Working Committee, Revenue Analysis Working Committee.
Yes.
Okay. Oh, I see. That's why it's called ROC, R-A-W-C, and what it does is, from time to time, because these forecasts are made, it looks into the economic performance, and then between the Treasury and the Reserve Bank and the SARS, it is then said, look, we either overestimated the performance of the economy, and therefore we must revise the forecast, and that is now what is called an under-collection. So you change the focus. And the point that we have made in the document is that a similar thing happened in the case of Mr. Godan, where the under-collection was 60 billion, maybe 6-7 years ago. So you can imagine by today's terms, 60 billion would be maybe 70, 80 billion. So this thing about the 50 billion is completely misunderstood. Secondly, we say that Mr. Moyane, having collected you'll hear, I'm sure, in due course that if there's anything about him, he's the trillion rand man, because for the first time this country collected a trillion rand, which is something that has never happened since 1652. And so it's very important to see it in perspective. This year alone, he actually achieved 100%, mathematically speaking, collection.
Yes.
Where he collected 1.2 trillion and ran short of 700 million, I think, which is 99.9. So
I will alert the man to this and whether he's taken that into account.
Yes. Thank you very much.
Thank you.
Otherwise, we are prepared later to give more light.
What is the time, Slanda?
12:20.
I'm going to suggest, and I hope your witness won't mind, that we leave it for an hour and start at 1:30, if you don't mind. I'll talk to him, and no, we're going to start at 1:30.
Judge Newton, I wanted to say now, can I have a cup of tea? Thank you very much.
I'm sure they'll give you one outside.
Thank you. It's taxpayers' expense.